Good afternoon, and I'm sorry to start while some people are still in line, but we don't have much time, and I have been told by the members of this panel that they have a lot to say, and so we will start. The United States Supreme Court usually finishes its business in July, and every year there are interesting cases. This past year was particularly an interesting set of cases, and indeed when I was in China this summer, and I had a chance to meet the equivalent of the Chief Justice of the Supreme Court, he turned to me, and I'm very intimidated, and this is a very amazing experience. The first thing he says to me is, "Your court decided that same-sex couples can marry. We would never do that." So while I normally would be a little embarrassed about the parochialism of focusing on the Supreme Court, I have no doubt that last year's term was important globally. And we will therefore turn to this wonderful group of commentators to explore some of the high-profile cases. We will start with the marriage cases. We will also turn to affirmative action, and we will turn to the voting rights case. If I cut people off, it's because I want to get to all of the cases. We're not, though, talking about many other cases that were also important this past term, which include the question about patenting the human genome or self-replicating genes, or the access to court question with regard to arbitration. There are many, many other important cases, and maybe if there's enough interest, we'll do another panel. But right now, we're starting with these. And we're going to begin with the marriage cases, and Professor Mike Klarman has agreed to lay out the factual and legal context before we have a discussion.
Thanks, Martha. It was a good term for the Red Sox, a bad term for the Yankees, and a so-so term for gay marriage. So the court decided 2 gay marriage cases, and I'll just try to lay out the basics because I know everybody on the panel probably wants to offer you their opinion and insight about the cases. So Windsor involves the Defense of Marriage Act. The court struck that down. The Defense of Marriage Act has multiple provisions, but for purposes of this case, the relevant provision provides a federal definition for marriage, meaning that even if a state like Massachusetts allows gay couples to marry, under federal law, that marriage will not be recognized. So, for example, for purposes of filing a joint federal tax return, purposes of immigration law, bringing your immigrant spouse into the country, the federal government defines marriage as between a man and a woman, and the Supreme Court struck that down. The law had been adopted in 1996. It was directly in response to developments that were going on in Hawaii at the time when it looked like the state court system was about to rule that same-sex marriage was protected under the state constitution. This was during a presidential year. Democrats would have derided this as election year politics, but the statute passed in the House and Senate by margins of 5 and 6 to 1, and President Clinton signed it into law, albeit somewhat reluctantly, accusing Republicans of playing politics with the issue. The court struck that law down in Windsor by a 5-4 margin. There's a lot of federalism rhetoric in the opinion, but ultimately it does not rely on the notion that Congress lacks the enumerated power to do this. Rather, ultimately, it's an equal protection holding, with Justice Kennedy emphasizing that the only purpose of the law is to disparage and demean same-sex couples whom the states have married. That fits it into a body of precedent dealing with laws that can only be animated by animus, and the court has ruled those laws off limits. The other decision is Hollingsworth. Hollingsworth involves the question of state same-sex marriage. Just to give you a tiny bit of background, the Massachusetts Supreme Court in Goodridge in 2003 became the first state Supreme Court to rule that same-sex marriage was constitutionally protected. That led in the next couple of years to 20 or 25 states passing state constitutional amendments barring same-sex marriage. The California Supreme Court was the second state court in the spring of 2008 to rule in favor of marriage equality under the state constitution. The voters of California then passed Proposition 8, which overturned the state court's interpretation of the state constitution, barring same-sex marriage. The Ninth Circuit then invalidated Proposition 8 on a fairly narrow equal protection rationale, and the Supreme Court granted cert in Hollingsworth versus Perry. Now, the way commentators set this up, the court had several different options at its disposal. It could rule flatly against any constitutional right to same-sex marriage. It could rule in favor of such a right, but it could do it broadly or narrowly. The narrowest solution would be to simply affirm what the Ninth Circuit had said, which would be to say it's irrational for a state to allow same-sex marriage, then to take it away while still allowing civil unions, which provide all the rights and benefits of marriage, but not the formal title. Or the court could have done what the Obama administration urged it to do in the Justice Department brief, which was known as the 8-state solution, which would have said that any state that has adopted civil unions, which at that time was 8 states, which provide all the rights and benefits of marriage, but not the formal title, those states have undermined their own justifications for not allowing same-sex couples to marry. Therefore, those states are behaving irrationally. Therefore, those states have to allow same-sex marriage. Or the 50-state solution, which is to simply say there is a federal constitutional right to same-sex marriage. The court did none of those things. Instead, it ruled 5-4 that there was no jurisdiction because the official proponents of the initiative, who were the ones who appealed the loss in the district court to the Supreme Court, according to the Supreme Court, those official proponents of the initiative are no different from an average citizen taken off the street, and an average citizen taken off the street does not have standing to defend a state statute that's being challenged in court. Many commentators thought the dissenters had the better of the argument on the jurisdictional issue, which would mean that the justices in the majority ducked the issue because they were not apparently ready to pronounce on the issue of same-sex marriage.
Great. You got me mid-chew.
Sorry.
I think you may have said this, but I think it's important to emphasize that California decided not to defend the law, and therefore we were left only with private litigants offering to defend the law. And so now we'll turn to comments on it. And Mike, do you want to start?
Sure. So I'll say two things, and I'll try to keep this brief because I'm sure everyone has things they want to say. First, I think it's very plausible to see the majority as ducking. I think the dissent actually does have the better of the jurisdictional argument, but I'm not going to go into that because it gets pretty detailed pretty quickly. I think the majority's ducking. I think the reason why they're ducking is because they're concerned about the possible backlash effect of a decision imposing same-sex marriage on the states. We know Justice Ginsburg has both written law review articles and given numerous speeches around the country, including in the last year, about how Roe versus Wade was a mistake because the court got involved too quickly and too aggressively with regard to the abortion issue, and she seems to see same-sex marriage as being analogous, although she's never come out and flatly said that. In the oral argument, both Justice Kennedy and Justice Sotomayor said things suggesting they didn't understand why the court should be tackling this now, why not let it percolate for a while in the lower courts. Opinion in the country is shifting very quickly. Why should the court risk a backlash? Although interestingly, Sotomayor and Kennedy both voted with the dissenters, suggesting that the court should have taken jurisdiction. I think it's a very interesting question whether that interpretation of Roe is right. That is extremely controversial among commentators. People like Reva Siegel and Linda Greenhouse think that Roe actually did not create a big backlash. People like Jerry Rosenberg and myself think that Justice Ginsburg probably is right about Roe. But even if she's right about Roe, that doesn't mean that same-sex marriage is the same thing. I actually think there are two big differences between abortion and same-sex marriage, which lead me to doubt that a 50-state solution would have produced a dramatic backlash, like, for example, Brown versus Board of Education did in the South, or like I think Roe versus Wade did. I'll just mention one of those factors, which is the directness of the effect on the people who lost in court. After Brown versus Board of Education, white people who believed in white supremacy had to send their children to school with African Americans. For them, in the 1950s, that was the end of the world as they knew it. People who oppose abortion think it's murder, and they have to experience murders taking place down the street in an abortion clinic. While I don't think that gay marriage has no effect on traditional understandings of marriage, it is very hard, I think impossible, to imagine a direct effect equal to that in Roe or Brown. Right? If you oppose gay marriage, Now what's going to happen is the gay couple living down the street in Jackson, Mississippi is going to be able to get married rather than just live together down the street. That's not a very direct effect on people's lives, and I doubt it would produce a dramatic backlash. The other point to note is just the likely path of development. I think the court probably should have ruled in favor of the 50-state solution. As a commentator, I'm interested in backlash, so it would have been interesting to test the hypothesis. Plus, I think gay marriage is right and just, and therefore the sooner we get there, the better. But leaving that to one side, I don't think this is a huge loss for the gay rights movement. What's going to happen is the fight's going to continue state by state. Hawaii's having a special session of the legislature that will probably vote for same-sex marriage this fall. Illinois is this close to gay marriage and may well adopt it also this fall. Oregon's going to vote on it next year, and it's almost a certainty that voters will vote in favor of it. New Jersey could take a vote on it, or it's even possible that Democrats will produce the supermajority to overturn Governor Christie's veto of a same-sex marriage law. If you look at Nate Silver's projections, and Nate Silver knows everything, so there's no reason to doubt his projections. He started out as a baseball prognosticator, but of course he became famous as a political prognosticator. Nate Silver has a model which predicts when opinion in each state will have produced a majority in favor, and it's based on a fancy regression model where he looks at all the past referenda. And what he finds is by 2016, which is just 3 years from now, there will be a voting majority in favor of gay marriage in 31 states. And by 2020, which is just 7 years from now, there will be a voting majority in every state except for 6 in the Deep South. And at that point, you're just going to have a court come along and say, well, of course, there's a federal constitutional right, and suppress the remaining outliers. So it's not a big victory for the gay rights movement that the court ducked, but I don't think it's a really big defeat either. Gay marriage is inevitable. I think people are recognizing that. A recent poll showed 72% now recognize it as inevitable, and even among opponents, 59% recognize it as inevitable. So it's very hard to see how that dramatic shift is going to be played back, is going to be retarded. I just don't see that happening.
Thank you, and thanks for starting us off so well. Professor Brown-Nagin would like to reserve the balance of her time to talk about Fisher. Is that correct?
That is correct.
All right, so we turn to Professor Fried.
I always used to think of myself as an anti-Klarmanite. That is to say, I always thought of myself as somebody who really believed that justices and the decisions of the Supreme Court were moved by, and indeed determined by, the force of legal argument. Well, this case gave me considerable pause. Consider the fact, some of which were laid out by Mike, who's the master of these things. Consider the fact that the nationwide polling data indicated that most people thought that DOMA should go, that the federal government had no business deciding this issue for the whole nation, and also that the Supreme Court should lay off. Now, lo and behold, what happened? The Supreme Court said Congress has no business here, and the Supreme Court, by a piece of jurisdictional jujitsu, concluded that there was no standing to decide the California case. The result was that California's gay marriage continued in effect because Prop 8 had been struck down, and that decision had not been effectively appealed, and DOMA went. Well, turn to the actual arguments and the actual doctrine, what we do here. Well, the force of public opinion about DOMA was that was federalistic. That is to say, this is not something that Congress should be dictating. Judge Boudin in the First Circuit, who also held DOMA was unconstitutional, could not bring himself to decide it on federalism grounds, for the reason that the arguments aren't there. Or if you make the arguments, they have entailments in other areas which nobody would be willing to accept. And therefore he did it on equal protection grounds. Justice Kennedy decided it on grounds which, frankly, I would describe as the more you explain it, the less I understand it. It had this absolute, full-throated aria about dignity and the dignity of gay couples and so on and so forth, and the mysteries of life, that kind of thing he trades in. But he did not say that this meant that the whole issue he did not emit an opinion which unqualifiedly, unreservedly would mean that to preclude gay marriage anywhere in any jurisdiction would be unconstitutional. He had this complicated view about how it was a denial of dignity which the state has conferred, suggesting that if the state has not conferred this dignity, the dignity has not been denied. As they say, go figure. The other issue, much discussed, and a preliminary issue was this case properly here at all? Because the federal government had not appealed it. President Obama, quite inappropriately and overly politically and badly, decided he would not defend the law because he found it offensive. That is not a sufficient reason. And his Attorney General and his Solicitor General should have known that, because each of them assured, as every Attorney General and every Solicitor General has done, I did it, assured the committee that confirmed them that they would defend the constitutionality of acts of Congress unless there was no respectable argument that can be made in their favor, or if it trenched on the powers of the president. And neither of those conditions were met. And the result was that the president was willing to risk an odd and unsatisfying answer which said, the case is not here. By this jujutsu, they concluded that the case was there, that even though the government was not defending the statute, and if the statute had remained undefended, then the judgment of the Second Circuit would have remained, or perhaps the Second Circuit would also have gone by the board, but of the district court would have remained because it was defended by the government, and you would have had the same result. President didn't do that. He obviously ordered the AG and the SG not to do that, and he took his chances. Well, that's a gamble he won. Now, you get to the California case, and I would have thought that the case for saying that the case was properly there and there was jurisdiction was stronger in California in the Prop 8 case than in DOMA. However, it went the other way, and the two cases lined up exactly as public opinion would have wanted. And as Mr. Dooley used to say, he was a cartoon character in the 1920s, the Supreme Court follows the election returns.
Thank you very much. If you have an empty seat near you, would you raise your hand? And so if you're standing up in the back, you can take a seat. I see so many people are not moving. Okay, well, we tried. So, Professor Justin Driver, do you want to comment on the marriage cases?
Yes, I do. So, 17 years ago, Mike Seidman at Georgetown wrote an article in the wake of Romer versus Evans, referring to the decision as the unexpected revival of the Warren Court. He said this with admiration. And the thinking there was, with good reason, that Romer did not pay all that much attention to the elaborate equal protection framework that has built up over time, and also simply, just simply neglected to cite Bowers versus Hardwick, a case that many people would have thought would have been on point, that had been decided a mere 10 years earlier. And so the idea would be that Simon was putting forth that Earl Warren would often ask during oral argument of counsel, yes, but is it fair? And this sort of concern about justice was animating the Warren Court rather than these fine sort of doctrinal niceties. 17 years have passed, but it does seem as though in the matter of sexual orientation that the court is concerned about justice, and one can hear echoes of the Warren Court in Justice Kennedy's opinion in the Windsor case. I think that there are strong similarities in the sense that the Warren Court's most famous decision, of course, Brown versus Board of Education, the most important language in that opinion talks about the expressive values of the law, and is also very much concerned with the expressive values of the law today. What do these laws mean today to Black children, right? What is the meaning of this law? And in Justice Kennedy's opinion, that same sort of language can be found. There is talk about, dignity and stigma, and he refers to the notion of second-class marriages and second-tier marriages, and the humiliation that sort of rains down from these things. He says, DOMA instructs all federal officials, and indeed all persons whom same-sex couples interact, including their own children, that their marriage is less worthy than the marriage of others. And so one can hear the echoes of the notion of hearts and minds and the the harm inflicted by Jim Crow on Black school children. And so one of the more interesting exchanges, I think, in the Windsor case is about the notion of bigotry and whether it, the invalidation of this act means that one is saying that in 1996 that was an act of bigotry. There certainly is some language in Justice Kennedy's opinion that suggests that there was a discriminatory purpose, and that is backward looking. But I think that the overwhelming balance of the opinion is focused on the meaning today that this carries and the expressive value of this today. So it's also perhaps worth saying that Justice Kennedy's opinion is obviously incredibly progressive in many ways, but it's also a conservative opinion in many ways, or at least one important way. It is a conservative opinion in that it elevates marriage to the pinnacle of society and a relationship that can exist at a time when marriage is being moved away from by many, many citizens. People of all different races are deciding that marriage is sort of effectively not for them. But Justice Kennedy does say that marriage is what confers dignity and status on people, and so we can see it as attempting to retain, some values in society. Okay.
Thank you. I think that we will turn now to Fisher, which raises the question about the constitutionality of the use of race in university admissions. And we will turn to Professor Brown-Nagin to lay out the case, and even if you want, give the first comment on it as well.
Very good. Thank you, Dean Minow, and it's a pleasure to be here with my distinguished colleagues. So the big news in Fisher is what the court didn't do. Contrary to the predictions of many, there was no, I would say, radical doctrinal change. But nevertheless, the court is nudging the law in a different direction. Universities are on the defensive as never before, as I'll explain. But first, let me lay out the doctrinal background in which this case was decided. The background was the 2003 cases, the University of Michigan cases. In Gratz, the undergraduate case, the Supreme Court struck down a policy that it deemed too quota-like, and thus violating Bakke. In Grutter, the law school case, the court found a compelling governmental interest in attaining the benefits of a diverse student body and upheld a policy that it found a holistic policy in which race was not decisive but a plus factor. In upholding that policy, Justice O'Connor wrote the opinion, 5-4 decision. She said that universities are required to engage in serious good faith consideration of race-neutral alternatives, and that these race-conscious policies have to be time-limited and not unduly harm whites, which becomes significant in Fisher. Now, in the University of Michigan cases, Justice O'Connor was viewed as having struck a grand bargain that would last for some time, including by Justice O'Connor. But then in 2012, we have a court granting cert in Fisher, this University of Texas case, which was a surprise to many and which seemed to be a harbinger that this court was interested in overruling or trying to narrow Grutter. And why was that? Well, because first, the University of Texas policy was written in the shadow of the Michigan policy. So it seemed to many that it was counterintuitive to think that the Texas policy would be unconstitutional if the Michigan policy was constitutional. Then there was something else about the Texas policy. Texas uses a unique approach, a layered approach, where one element of it is actually race neutral, and the race sensitive element is de minimis. So let me explain about the layered policy. Here is how it works. The race neutral element is a top 10% policy, where if you're a Texas resident and you graduate in the top 10% of your high school class, you are entitled to admission to the University of Texas. And this is the admissions pathway by which the overwhelming majority of students are admitted to Texas. This includes white students and Black and Hispanic and Asian students, anyone. So in 2008, the year at issue in the Fisher case, 88% of students were admitted through this top 10% policy. The other part is holistic review, and under holistic review, the university considers grades and test scores and a variety of other factors, including economic background, one of which may be race. So the record showed that in 2008, when Abigail Fisher applied for consideration, there were only 33 cases where Black and Hispanic students may have been admitted where race played a role. And it was never actually determined that race was the plus factor that permitted their admission because the policy in Texas is so nuanced, there's so much discretion for admissions officials that it could not be determined that race was the plus factor that enabled them to be admitted, which is significant. So if the policy is so nuanced, you might ask, why use it? Well, because the University of Texas determined that it had not achieved a critical mass of diverse students after it instituted the top 10% policy. It had significantly increased its percentage of Asian students who were not underrepresented, had measurably increased its percentage of Hispanic students, but the percentage of Black students was still pretty low, about 4%. This policy was reviewed after Ms. Fisher sued by the District Court and the Fifth Circuit. Both upheld the policy. In the process, the Fifth Circuit mentioned good faith deference to the university, and the question that was certified for review by the Supreme Court was whether the Fifth Circuit had properly applied Grutter, the Grutter standard. And what it held was that no, the Fifth Circuit had not applied the proper standard, and it remanded the case for further review. That's it. That's what the Supreme Court held in Fisher, which, as I said, was a surprise to many people who had predicted that the court wanted to go much further. The worst case scenario for proponents of affirmative action was avoided. The case was decided 7-1, with Kennedy writing the opinion. It's significant that in the opinion, Justice Kennedy said that Bakke and Grutter are good law. They're taken as a given. Chief Justice Roberts and Alito signed on to that opinion without writing a separate concurrence. That's significant. But it's hardly the end of the story. The devil is in the details, or God, however you prefer it. And here, the details all concern the evidentiary showing that has to be made even before universities can turn to race-sensitive policies, the question of narrow tailoring. The point of the opinion that Justice Kennedy wrote is that strict scrutiny has to really be strict. It has to be vigorous rather than feeble. And here's the language, and I want to read it to you, that he wrote about the application of strict scrutiny. He said, "Good faith consideration is necessary but not sufficient to satisfy strict scrutiny. The reviewing court must be satisfied that no workable race-neutral alternative would produce the educational benefits of diversity." Now, compare that language to the language of Justice O'Connor in Grutter. She said that universities should engage in serious good faith consideration of race-neutral alternatives. This language was affirmed in Parents Involved. So what Kennedy is doing is finessing the language of O'Connor, her application of strict scrutiny, on the view that Justice O'Connor, the Grutter court, never really seriously applied strict scrutiny. So the language, the emphasis is slightly different, but it seems to me that it's meaningful, that it does suggest a different orientation towards affirmative action. It seems to me that the court is suggesting subtly a preference for the race-neutral alternatives and its disfavor of explicitly race-conscious holistic review. So it's clarifying Grutter in that way. And I should turn to you and ask if I can I continue? Okay, I reserved my time. The long-term impact then, I think, and what the court is doing is that it's whittling away at diversity-based affirmative action in higher education in much the same way that it whittled away at affirmative action that was justified on a remedial basis. So there are cases going back to the 1980s and 1990s, cases like Richmond versus Croson, where the court never questioned the history of discrimination in this country. It's hard to do that, particularly in a case involving Richmond, the cradle of the Confederacy. But what it said was that the kind of affirmative action programs that were at issue in that case were too broad given the evidence. So, for instance, the city of Richmond might be able to justify an affirmative action program for African American contractors, but it couldn't do so given the evidence of the Jim Crow era for Hispanics. So that is the way in which the court over time whittled away at the remedial programs. And I do think that a similar analytical move is at issue on the diversity side, although it is said that the diversity strand of the doctrine and the remedial strand are two distinct strands. I don't think that if you look at the cases, that is actually so when it suits the court. Practically speaking, I mentioned that the court remanded the case to the Fifth Circuit. Oral argument will occur in November. The question is, what would actually satisfy the court that a race-sensitive approach is permissible for UT, but also for other universities if they are challenged? And here's the thing. It happens that race-neutral approaches, so examinations of things like wealth or income or zip code or geography, will produce some racial diversity. The question is how much, and whether universities are still permitted in practice, as opposed to in theory, to pursue a critical mass of diverse students. And furthermore, how is one supposed to know it when one sees it if you can't look too hard for it, which is the nature of the law as I see it. And this kind of analysis, this rubric, is really odd as applied to UT because, well, the question is, what can UT do that it hasn't already done? It's conducted impact studies. It's a university that, because of some backstory involving a pre-Grutter Fifth Circuit case, it can point to what its student body looks like without any affirmative action, with the top 10% policy, and then with both. So it'll be really interesting to see what the Fifth Circuit does. It may order the collection of more evidence, and we'll see what UT can proffer. One comment about Justice Ginsburg's dissent. There, she voiced skepticism of the top 10% policies on the basis that they're not really race blind, that they're in fact race conscious, because the legislature was aware of pervasive de facto segregation in schools and in neighborhoods. Well, I, of course, take the point, and yet I'm a little puzzled by the extent to which Justice Ginsburg's opinion is perhaps jumping to some conclusions that aren't warranted by the doctrine or by the facts. And what I mean is that it matters that the policies are, in fact, facially race neutral. It matters that the percentage plan is the pathway of admissions for the overwhelming number of whites, as well as Black and Hispanics and everyone else. It matters that the legislature was aware of the impact, positive impact, on whites as well as these other students. The totality of the evidence, I believe, has to be the touchstone of that analysis. And, the Texas state legislature is not really known for its beneficence towards blacks and Hispanics without regard to the impact on whites. And I think that has to be considered. So in the final analysis, I would say the takeaway is that the court is nudging universities away from these race-conscious policies, nudging opponents into court. But I think that universities can adapt and survive in this new legal environment by scrutinizing these other facets of applicants' experience that are intertwined with racial diversity if they're so inclined, but they're more costly, more time-consuming, and they won't work in all places and all times. But on the other hand, perhaps a silver lining is that the court keeps creating more work for lawyers and law professors, so maybe that's not so bad.
Thank
Thanks.
you very much. Professor Klarman, would you like to comment on Fisher?
You had me last in the order. You
I'm
changed
sorry,
your mind.
I'll switch. I'm sorry, I'll switch. Justin Driver, would you like to comment?
Sure.
Sorry.
So the news about Fisher is in many ways that there's not a whole lot of news here at all. Affirmative action has been, since the days of Bakke in 1978, been thought to be on the way out. It's been given its last rites before Bakke and before Grutter as well, right? The decisive vote in Bakke came from Lewis Powell, an unlikely source, and Justice O'Connor's opinion in 2003 upholding the University of Michigan's law school program was also something of a sea change from where she had been before in cases like Croson and Adirond. I do think that the practical effect of the opinion will signal to judges on the district court and on the Court of Appeals that one can place quite a lot of emphasis on the narrow tailoring approach. But it is miraculous in many ways that I think that the program was not invalidated by the court, in the sense that the existence of the Texas 10% plan, which is responsible for admitting the overwhelming majority of African American and Hispanic students to the law school, to the undergraduate institution, sort of removes the guesswork associated with whether there is a mechanism that does not classify individuals according to race that can get some measure of diversity. Many people thought that the court's opinion would have said, perhaps critical mass, whatever that means, is achieved through the Texas 10% program, and you need not have this additional layer on top of it. But the court decided not to go that way. I think in many ways, the most interesting things about Fisher are the way that it highlights some of the instability of the Equal Protection Clause and current thinking about the Equal Protection Clause. The traditional view for a long time has been that there's an anti-classification colorblind view, which is skeptical of affirmative action, and that there's an anti-subordination view of the Equal Protection Clause, which says that affirmative action is just fine. Justice Kennedy has done some of the important work here, where he attempts to disentangle the notion of anti-classification from colorblind, right? And so he wrote an opinion in the Parents Involved case where he says we need not be colorblind, but the real harm that comes from these sorts of programs is when people are classified according to race. And so he says that the building of schools or the drawing of district lines by school districts is permissible and may not even draw strict scrutiny in his estimation. And so the Texas 10% plan should be, according to his logic, fine. There is some difficulty there in the sense that the court has placed a lot of emphasis on saying, how are we to tell what is a program that's designed to benefit racial minorities from one that is designed to harm them? And so there is some difficulty there. The anti-subordination ground is also complicated, I think, by Justice Thomas, who many people thought that, well, if you're an anti-subordinationist, then you think affirmative action is okay. Justice Thomas, again, in the Fisher opinion, which is a remarkable opinion, he spends lots of time saying that the people who want affirmative action today are just like the segregationists of old, and indeed even like people who supported slavery, which is quite an aggressive argument. But he does say that I am an anti-subordinationist, and that the classification itself suggests that black people are not up to the task intellectually, and that it subordinates them. And so one might have thought that Justice Thomas would have dedicated some serious attention to original understandings of the 14th Amendment going back to the 1860s. He did cite one case from Iowa. The trouble is that the case is interpreting the Iowa Constitution rather than the United States Constitution. And it also did come out before the 14th Amendment was actually ratified. But other than that, it's a perfect citation and everything, and it explains why affirmative action is invalid. I'll stop there.
Professor Fried.
This case also makes me a Klarmanite. As somebody who, in fact, litigated a number of these cases, including Croson, and proposed what was the winning opinion by Justice O'Connor. Let's just cut through all the stuff. What is it that a university president really thinks he or she is doing in her heart of hearts? What they're doing seems to me, they're looking out at the world and saying, this is a country in which black people have been terribly treated for hundreds of years, and they are obviously not in the same situation as other people. And we've got to change that. That's a terrible result. It is a terrible result when a large part of our population, clearly, evidently present in a way that the gay population is not, is in an equally evident way in a situation of subordination. You look at boardrooms, you look at classrooms, and so on and so forth, elite institutions particularly, and they tend to be, would want to say all white, but they tend to be with a very significant deficiency of black people, and that is unacceptable. That's a terrible situation. All right, let's fix it. I'm the president of Harvard. We can really help by getting a number of very able black people in our classrooms everywhere, and they're going to go, yeah, well, that's a wonderful motivation. It's undoubtedly the motivation that's present everywhere, and it is the motivation which Bakke and Grutter, yes, Grutter, says is illegitimate. Well, you pay a price when your real reasons are the reasons that are not used, are not put forward, are not given, and some other reason, such as the totally phony diversity reason, is brought forward and used. And the price is doctrinal incoherence, which is what you had in the two University of Michigan cases. Look at the two cases. The law school, which admits a class of about 350 people, the affirmative action plan there was okay. The undergraduate school, which admits a freshman class of several thousand, was not okay. Why? Because at the University of Michigan, and this was developed in the district court record, their admissions committee knew the race of every single applicant. They knew what percentages, they had a rolling admission policy, what percentages were being admitted, and this was distributed to the committee on a weekly and towards the end of the season, daily basis. Now, Chief Justice Rehnquist said, hey, come on, let's just admit what's going on. No, this was holistic. What then Bollinger was saying, well, you know, Rehnquist said, that can't be right. Why do you do this? And why is it, as a matter of fact, that the critical mass of people in the law school exactly mirrors the percentage in the population of each racial group? Pure coincidence, huh? On this holistic... Well, now, in the college case, that was struck down, impermissible. Why? Because when you're dealing with tens of thousands of applicants and you have to admit a couple of thousand, you got to use a bureaucracy and you've got to give some kind of guidelines. And these guidelines, if you're going to produce the result, have got to be explicit. So what it does is it smokes out what you're doing. And as both Justice Ginsburg and Justice Rehnquist said, each in dissent of the two cases, these cases can't both be right. Well, what's going on? What's going on is everybody knows why we have affirmative action. It is to integrate the society. And the only way to effectively integrate the society is to try to integrate it and to be race conscious. But there is a deep discontent about the notion that if we do this forever, we're going to end up not with an integrated, but with a stratified society. Balkanized is the word that was used in Croson, where each racial group is going to have its quota, its percentage, and you might even have political representation on racial grounds, and that will be the new federalism. That would be terrible, and that would be the exact opposite of the American notion of a melting pot and the unity of all mankind. That would not. So how do you avoid it? Well, you avoid it by pragmatic political decisions which say, we're not there yet, we've got to titrate this, we need some more race-conscious thing, but let's make sure we don't do it more than we have to. That is not a kind of decision which is amenable to the Procrustean bed of constitutional doctrine and district court analysis. That's a political decision, and it requires political judgment. And I'll say just one more thing. You remember Bill Clinton? It's so long ago, maybe you don't remember. But when he was picking his cabinet, he said that I will rest content when my cabinet looks like America. This problem will be solved when families look like America. And this problem will be solved when we really, truly look at each other. And as my young grandchildren, they don't notice the race. A race is not the salient feature. That will be wonderful. And how you get there is a pragmatic political matter which is beyond the capacity of the Supreme Court to capture in any formula.
Thank you. Professor Klarman, would you like to comment?
In the interest of saving time for questions, I'll waive my comment on Fisher, but I do want to say that I'm 100% sympathetic to Charles's Klarmanite observations about the case.
Well, I will just say one thing about Fisher. There is a collision course between the court's rejection of quotas in the Gratz case and any discussion of critical mass. These cannot both be made, they can't be made compatible. So I agree with Charles that the doctrine is incoherent, but I also think it's incoherent to say it's permissible, as the court has said, to have a holistic review of candidates and also say you can't look at their race. Because last I looked, if you look at a person, their race is part of who they are. So it's an incoherent doctrine. I think that that is true. Mike Klarman, would you introduce the Shelby County case?
Do you want to do that, or do you want to take a couple questions, because we've only got 5 minutes? What would you prefer?
Let's have a show of hands. How many people want to have questions? How many people want to have Shelby County? I think that that's what we're going to do.
Okay. All right. Well, I don't think I can do this in less than 2 or 3 minutes, but I'll try to be as quick as I can. So the 1965 Voting Rights Act is one of the crown jewels of the civil rights movement. It's also one of the most efficacious laws in the history of the American Congress. It was addressed to the issue of the massive disenfranchisement of African Americans that was accomplished in the South, notwithstanding the 15th Amendment, which says you can't disfranchise based on race, notwithstanding that 0% of African Americans were registered to vote in the South by about 1900, 1910. It had changed a little bit by the 1940s and 1950s, but in the rural South, there were literally dozens of counties with a majority of the population being black, where not a single black person was registered to vote, and that was the case as late as the 1950s. What the 1965 Voting Rights Act does is, by suspending literacy tests and by threatening to appoint federal registrars to replace state registrars, it dramatically increases voter registration, especially in the pockets of the rural Deep South where there had been so little. So that, for example, Mississippi, the worst, the most egregious instance, where blacks were 6% registered, 6% of age-eligible blacks were registered to vote in Mississippi in 1964. That went up to 60% within literally just 2 years of the enactment of the Voting Rights Act. The issue in the Shelby County case is the geographic coverage formula, which governs what's known as the preclearance provision. Preclearance was an extraordinary remedy that Congress used in 1965 to address this extraordinary problem of almost universal black disfranchisement in the rural Deep South. Under the preclearance requirement, Congress says that covered jurisdictions, and I'll say a word in a second about what defines the coverage, covered jurisdictions actually have to go and pre-clear any changes in their voting rules. So if they want to add a voter ID requirement or they want to change places for voting, they have to go to a federal court in Washington or to the Justice Department and get preclearance, which is the opposite of way things usually work. Usually states pass laws, somebody gets to challenge it in court. Under preclearance, if you want to adopt a new law, you have to get it pre-cleared, and the burden is on you to show that the change neither has the purpose of discriminating based on race, nor does it have the effect of making it harder for minority voters to elect candidates of their choice. It was an extraordinary measure, telling states and localities they have to go hat in hand to Washington to get their laws pre-cleared, but it was responsive to an extraordinary problem, which was a near universal nullification of a constitutional amendment. The coverage formula was based on voting from the 1964 presidential election. If you had a voting requirement in place, a device or a test, and they're mostly thinking of literacy tests, if you had that in place in 1964 and voter turnout was less than 50% in the 1964 presidential election, then you are subject to the preclearance provision of Section 5 of the Voting Rights Act. That formula was designed to capture the South, and that, in effect, is what it mostly captured. Congress periodically reproduced the Voting Rights Act. It had sunshine sunset provisions. So it was renewed in 1970, it was renewed again in 1975, it was renewed again in 1982, and then it was renewed again in 2006. But the coverage formula never changed. They used the same coverage formula based on 1964 and whether you had a voting test and whether voter turnout in the presidential election was less than 50%. The court said in Shelby County by 5-4 vote, the usual 5-4, conservatives on one side, liberals on the other, Justice Kennedy providing the difference, and in race cases he tends to vote with the conservatives, although in gay rights cases he actually tends to vote with the liberals. The court says times have changed. If Congress wants to continue with this extraordinary imposition on what it says is state sovereignty, if you're going to require different rules for different states, you can't do it based on a rule that you adopted almost 50 years ago. You have to come up with a geographic coverage formula that's not geared to voter turnout in 1964. It has to be geared to some sort of problem today.
Well, I think that was extremely well done, and it takes us to 1 o'clock. So the session is formally over, but maybe people will stay after and give comments, because everyone has great comments to give on this case. Thank you all for coming.